it's as if the person who wrote this wanted schools to remain soft targets.
Yeah, it's very baffling. We're the Armed Attorneys. Today we're talking about the so-called Bipartisan Safer Communities Act that is making progress in the Senate. Now, this thing is hot off the presses, and so much so that at the time of this filming, it hasn't even been assigned a number yet. But it's important we discuss this because there's a very high likelihood that this is going to pass out of the Senate, pass in the House of Representatives, and it's probably not going to be vetoed by Joe Biden. So this has a high chance of becoming the law, and there's a ton of gun control provisions in it, and you're going to want to stick around through each of these because up until the very end, some of this stuff is extremely important, and you need to be made aware of it. But before we begin, show your support for the Second Amendment by hitting that like button. To start off the conversation, let's talk about, disclaimer here, we're not going to go through section by section. We are going to highlight some of the most important sections, though, and how the kind of mechanics of this stuff is going to work, because it's going to get blended in with our current jurisprudence, our current law, and there's going to be some modifications. The first big one comes from section 12001, and this relates to kind of a purchase delay for 18, 19, and 20-year-olds. And can you walk us through that, Edwin?
Yeah, it's going to make your juvenile records part of the NICS background system for those 18, 19, and 20-year-olds. And now keep in mind, this entire bill is written in the nature of a compromise. And as we all know, the compromise always works adverse to the rights of the gun owners. But keep in mind that the anti-gun folks, they wanted a hard no purchase of a firearm by anybody under 21. So this at least does not do that. An 18, 19, 20-year-old still can purchase a firearm, but they may get delayed by as many as 14 days.
Yeah, and so the logistics, what this looks like, 18, 19, or 20-year-old goes to a federally licensed dealer. Again, this only applies to licensed dealers. They say, hey, I want to buy a long gun. At that point in time, the FBI, through the NICS system, the National Instant Criminal Check System, will delay that purchase for at least 3 days. And in that time period, the FBI is going to reach out to the repository of juvenile records, the repository of mental health records, and the local law enforcement officer and say, hey, is there any reason or cause that we need to not proceed with this transfer to this 18, 19, or 20-year-old? Now, if they all respond in 3 days and say no cause, then that transfer could theoretically take place within 3 business days. But if any of those 3 repositories say, hey, we have cause and we have a reason to think that this person shouldn't be transferred a firearm, then they have, the FBI and the NICS system has an additional 7 days, so up to 10 business days to further investigate and confirm or deny whether that person is prohibited under federal law from purchasing firearms or ammunition. Now, it's important to highlight this business days because this is what we're talking about, and it doesn't contemplate weekends. So that's why we have that up to 14-day delay for 18, 19, and 20-year-olds. So that's kind of the first big one that jumps out. The next big section that kind of came to our attention is the section 12002, and this is kind of a huge expansion, and I think this relates to them wanting to get at universal background checks, but for folks engaging in the business of firearms. And what do we learn from this section, Edwin?
Well, previously, a person has been prohibited from engaging in the business of selling firearms without a license, and this has traditionally been looked at through the sphere of profit motive. Was somebody doing it to make a profit, or were they running it like a business? And this has altered the definition to say that instead of a livelihood and profit, they are just simply using the words to predominantly earn a profit, which means that if profit motive or profit is in the overall scheme of you selling this firearm, then the ATF could consider you to be engaged in the business.
Yeah, so what does this look like? A practical example, I'll give you an example under current law and under what this provision, if this act becomes law, what it would look like then. So let's say we have a guy who only owns one gun. He purchased it a few years ago, and it has gone up substantially in value, and he says, man, I could probably make some money on this thing now, and he goes and he sells that firearm. Well, under the current law, he probably would not be considered engaging in the business of firearms because while he is motivated by profit in this circumstance, he's not really using this to generate his livelihood. You know, he's not living off of the sale of this single gun, and so probably would not be considered as engaging in the business. Now, fast forward, if this act were to go into effect, because the man's primary motive in the sale was making a profit, even though he's only selling one gun, that would probably make him qualify as engaging in the business of firearms. You know, if he doesn't have an FFL, then they're going to say, hey, look, you're engaging in the business without an FFL, and therefore you're violating federal law. So it's really, really important. Now, I think an important note that comes out of this is they say, hey, this primary motive for profit does not apply to folks who are making multiple transactions, to, you know, criminals if they know this stuff is going to be used in criminal activity, if they're transferring it to gang members, cartel members, drug traffickers. And so, you know, that can cause some real serious problems, because we see this where the rubber meets the road. What's a scenario that comes up for you, Edwin?
Yeah, for example, let's say that an individual has sold several firearms over the last 6 months, last year or so, and it just so happens that 2 of his firearms turn up in 2 separate crime scenes. You know, one's used in a liquor store robbery and one's used in a carjacking. The ATF or the local police do a firearms trace, comes back to this singular guy, then they will be allowed to investigate him and possibly prosecute him as a firearms trafficker without having to establish the whole profit motive.
Yeah.
Just the fact that he seems to have engaged in a regular business of selling or transferring firearms to people who engage in criminal activity, that would be enough to sustain a charge of being an unlicensed dealer. And one thing that was very interesting about this law, or this bill, this proposed law, is that just in case you out there were confused about whether or not it was legal or illegal to sell firearms or ammunition to a drug cartel, this law specifically will delineate that you cannot sell firearms and ammunition to agents of a drug cartel.
We see that pop up over and over again. That's in section 12004, where they make it really clear they don't want firearms making it into the hands of criminals. But backing up a little bit to section 12003, this is where we see the red flag provisions of this proposed act come into play. Now, this is, you know, Edwin mentioned earlier how the hard and fast raising the age to purchase long guns to 21 was the goal of the gun grabbers. You know, the goal of the gun grabbers in this instance was to have either a federal red flag confiscation scheme where federal district courts would be administering these emergency risk protective orders, kind of their intermediate, you know, their second best, what could we get, came in the form of, hey, states, we're going to tie funding to, you know, public safety or maybe even schools or something else to you implementing a red flag law. What we get in this bill is a little bit better, I will say, compared to those 2 alternatives, but it's still, we believe, a violation of a person's Second Amendment rights to due process, violating the Fifth and Fourth Amendment. Now, how do they do it, though? They do it through a provision where they say, states, we are going to make funds available in the form of grants for all kinds of different services, and they list off mental health, telehealth, juvenile mental health, and this is a part of an existing grant scheme. But what they have plugged in this system now is, hey, you will be able to apply for grants if you adopt an emergency risk protective order system. And they have built in some protections here. You know, they give a nod, or at least a feigning nod, you know, glance to, hey, we want you to have due process when you set up this system. But, you know, obviously no red flag law is better than a red flag law. And so for that reason, you know, it should be opposed and then, you know, is considered a gun control measure. Did you have anything to add to that?
Well, this provision does say that any red flag law that a state produces must adhere to the concepts of due process. And fortunately, it didn't just leave it as amorphous description of due process. It does include the specificities of what the law does recognize as due process, which would include notice, an ability to be heard in person, a right to counsel, a right to see evidence that the state intends to use against you, and the right to cross-examine adverse witnesses. So at least there is some acknowledgement that we do know that, or at least the government will recognize that red flag laws do implicate your due process rights, and that it will specify what those due process rights are. I will say that we are fortunate in that it does not mandate federal legislation on this. It does not create interference by the federal courts, and it is done just in this sort of enticement about having access to certain grant programs.
Yeah, and the one thing that I do think is noticeably missing from this is it doesn't lay out who would be allowed to make such a complaint. So it looks like they're going to leave that to the states. And we've seen kind of this spectrum of anonymous person who, has a grudge to pick to, sworn by a peace officer in front of a judge, and somewhere in between. So I did notice that who is allowed to make these kind of complaints was missing from that. But that takes us on to section 12005, and this is where they're expanding the list of prohibited persons for misdemeanor crimes of domestic violence to include what they call intimate partners or intimate relationships of a romantic nature. They also call this the boyfriend loophole or the Charleston loophole. And they give us some new language on who is going to be considered as disqualified under 18 U.S.C. 922. And what does that say, Edwin?
Well, the person who will be disqualified now is a person who has been convicted of a misdemeanor offense of dating violence. And it's important to remember, I just want to remind folks that in the event that somebody's convicted of a felony offense of domestic violence, they are now strictly prohibited as a felon. So that applies to any type of felony. So these crimes were dealing specifically with misdemeanor offenses, including those misdemeanor offenses that could be punishable by a fine only. So we have seen this with regard to this domestic violence. Domestic violence previously is defined in the federal law as involving current or former spouses, people who are in the same position as spouses, people who are both parents of children, things like this. But now it does include these folks who have had a dating relationship. That now includes a definition of dating relationship.
Yeah, and so the way that they define dating relationship is it means a relationship between individuals who have or who have recently had a continuous, serious relationship of a romantic or intimate nature. I do think that it's a little humorous that they define relationship with the word relationship, but that's the best that they could do. And now they've also given some additional factors of what should be considered when determining whether or not something is considered a dating relationship.
Yes, the length of the relationship will be considered, the nature of the relationship, and then most interesting, guess the courts will have to ferret this out, the frequency and type of interaction between individuals involved in the relationship. So they've outlined this, but they have made one notable exception about what will not be considered as a romantic relationship.
So they're not going to count a casual acquaintanceship of ordinary fraternization in a business or social context that does not constitute a dating relationship. Here's maybe a little bit of a light at the end of the tunnel. What they do is they've expanded the list of prohibited persons, but a person who would be disqualified under this provision may regain their firearms rights after a certain period of time. Now, what they're saying is that disability will go away 5 years after the person is convicted, the person's released from supervision or confinement, whatever the latest date is or action on that charge, that they would, assuming they're not otherwise prohibited for some other reason or they haven't committed some other misdemeanor crime of domestic violence, under this dating provision, that they would regain their firearms rights after 5 years.
And what is probably most important in this entire piece of legislation regarding the quote-unquote boyfriend loophole is that it is not retroactive. And so the non-retroactive provision, as well as the previously mentioned 5-year provision, are really two provisions that absolutely should have been in the original law.
Yep.
They were not, and as we've seen, somebody who was convicted of family violence in 1990, even though the law wasn't written until 96, now finds themselves a felon if they try to buy a gun in 2022. And that's really kind of turning jurisprudence on its head. And so it is nice that at least someone has recognized that and put in this 5-year time limit, as well as the fact that this can expressly not be used retroactively. So if you do happen to have one of these convictions in your background, it's not going to prevent you from purchasing or possessing firearms in the event that this does become the law.
Yep. And that brings us kind of to the last one. And I thought this was a little bit sneaky, and I'm interested in this. Is what I want to hear your comment in the comment section below. Of why was this provision included in this law? And that's section 13401, and that has to do with an amendment on what's called the ESEA, the Elementary School and Secondary School Education Act. Now, this has to do with the Department of Education funding, and what they snuck into this provision in this section was that, you know, we have this list of prohibited uses of funds from the Department of Education. The Department of Education says, hey, you can't use funds for XYZ. Well, they have included on this list that they cannot use funds from the Department of Education to train staff in the use of dangerous or deadly weapons. And so, you know, I think as a practical matter, what does that look like? Hey, teachers, you can't use Department of Education funds on training your teachers to defend their students, for school resource officers to defend their students. And I'm just kind of wondering why they put that provision in here.
It's really kind of baffling because obviously if this is about school safety, one of the major things that people have been proponents of is making schools safer by, you know, giving school staff the ability to defend themselves, because as we've seen, you know, the teachers are the first responders. And even when the first responders show up, they may not act like first responders. And so you would think that you would want to have the ability to allow a potential victim to be trained to defend themselves. And this kind of cuts it off at knees. It's as if the person who wrote this wanted schools to remain soft targets.
Yeah, it's very baffling. This may not be the final version of the law. Maybe there's some amendments coming down the line. If this changes, obviously we're going to post an update, but we hope you enjoyed this breakdown. If you did, consider subscribing, hitting that like button, and this is so important. Help us fight the anti-2A algorithm by sharing this video. We want to hear your questions and comments about this proposed act in the comments section below. And until next time, we're the Armed Attorneys.